Welcome to Law Family. This video is helpful to law students and newly practicing young advocates only. Today, we discuss about the section 227, 228 and 229 of BNS Act 2023. Corresponding law is 191, 192 and 193 of IPC. And also discuss the section 379 of BNS Act 2023. Corresponding law is 340 of CRPC.
Welcome. Section 227 of BNS Act 2023. Giving false evidence. Whoever legally bound by an oath or by an express provision of law to state the truth or being bound by law to make a declaration upon any subject makes any statement which is false and which he either knows or believes to be false or does not believe to be true is set to give false evidence. Section 228 of BNS Act. Fabricating false evidence. Whoever causes any circumstances to exist or makes any false entry in any book or record or electronic record or makes any document or electronic record containing a false statement and so on, it may appear in evidence in a judicial proceeding and so on, is said to fabricate false evidence. Punishment section 229 shall be punished up to 7 years of imprisonment with fine rupees 10,000. Other than that referred to in subsection 1 shall be punished with imprisonment of 3 years with fine rupees 5,000. Non-violable, non-cognizable, trial by magistrate.
Important points in section 227 of BNS Act. That is, a person must be legally bound by an oath or by any express provisions of law to state the truth or to make a declaration upon any subject. He or she must make a false statement, and he or she must know or believe it to be false or must not believe it to be true. Section 228 of BNS Act. Ingredients. One is causing any circumstances to exist. Second one is making any false entry in a book or record or electronic record, etc. Third one is making a document containing a false statement. Most important point
That such circumstances, false entry or false statement or morphing and manipulating false electronic record etc. must have been intended to appear in evidence in a judicial proceeding. Important. Appear in evidence in a judicial proceeding or a proceeding taken by law in public servant or an arbitrator before. Point 2. That such circumstances, false entry or false statement or electronic record containing false statement, so appearing in evidence, might cause any person who in such proceeding is to form an opinion upon the evidence to entertain an erroneous opinion.
important impact on judicial proceedings. Perjury can significantly disrupt court proceedings. It can lead to point 1, wrongful convictions. False evidence can lead to the conviction of innocent individuals. Point 2. Delays in justice. Court may need to conduct investigations or reopen cases to verify the truthfulness of evidence, causing delay in delivery of justice. Part 3. Point 3. Erosion of public trust. Erosion of public trust. Perjury undermines public confidence in the legal system. Point 4. Increased legal costs. Perjury can make legal proceedings more complex and expensive.
Procedure for perjury. Section 379 of BNS Act. Corresponding law is Section 340 of IPC. The court can conduct a preliminary inquiry to assess if any offence under Section 215 has likely been committed. Point 2. Subsequently, court must form opinion, record a finding to that effect. Point 3. Complaint to magistrate. The court then files a written complaint with first class magistrate who will handle the further investigation and potential trial.
Perjury in civil cases. Submission of a false affidavit. Submission of false affidavit or the fabrication of documents intended to be used as evidence. Civil courts are expected to take action against perjury to maintain the sanctity of the judicial process. The civil court can make a complaint to the appropriate magistrate for prosecution. If a hostile witness testimony is demonstrably false and made with the intent to deceive, they may be charged with perjury, but it depends on the circumstances and the judge's discretion.
Section 180 of BNS Act. Corresponding law is Section 161 of CRPC. Statements are not made under oath, they cannot be used to prove perjury. Section 183 of BNS Act. Corresponding law is Section 164 of CRPC. Statement recorded under this section is not automatically considered perjury. If a witness later changes their statement recorded under this section generally not considered substantive evidence in themselves. Judicial procedure steps on perjury. Preliminary inquiry. Before filing a complaint, the court typically conducts a preliminary inquiry to determine prima facie case for initiating proceedings. Complaint. The complaint under Section 379 of BNS Act, corresponding law is 340 of IPC, is made by the court itself. Different courts. A civil court might refer a matter to a criminal court for prosecution to avoid subject matter bias. Complaint does not have to be filed by the same judge or in the same court where the offence occurred. Lastly, under Section 223(1) of BNS Act, corresponding law is Section 200 of CRPC, a private complaint may not be entertained if the alleged perjury occurred in a court of law.
Thank you.